Hello, everybody. Thank you so much for joining us today for our Wednesday webinar. Just a little bit of housekeeping. This is being recorded, so if you do not wish to be part of the recording, feel free to turn off your camera. We do ask that during the presentation, you do keep yourself on mute, but if you have any questions during the question period, you're more than welcome to unmute yourself and ask your question. If you do not feel comfortable doing so, you're more than welcome to put it in the chat and I will relay it. But just a little bit of background, and I apologize in advance if I butcher any of the names. Shokouh Abadi, a Ph.D., a barrister and solicitor in Ontario, is the founder of Kimig Law and a TEDx speaker. She has extensive experience in business law, international commercial law, regulatory compliance, and anti-money laundering, and has taught various courses of law, including business law and contract law at different universities in England and Iran. She holds a Ph.D. and an LLM, Masters of Law in International Business Law. And take it away.
Thanks, Kylie. Good morning, everyone. Thank you for coming and joining the second session of our Business Law Bootcamp for growing your business, scaling up your business. I hope you've listened or joined the first session, which was about agreements and contracts. This second session is about mergers and acquisitions. Another kind of agreement for businesses, especially those who are in the stage of growing their business and scaling up their business. So I'm going to share my screen and start. All right. Just a welcome note and a reminder that this presentation is for educational purposes. And if there is any legal matter that you have, please seek legal counsel for that specific matter, because I'm going to cover general principles of law related to mergers and acquisitions. And they might not be applicable to your particular question or legal matter. So for any particular matter, legal question, consult with a lawyer, please. And the aim, of course, the aim of this presentation, as I mentioned in the first session, is to it's educational and is to increase your knowledge of business law so that you could, as women, you could get more power in making decisions, especially related to legal issues. And as I said, please, for any particular matter, seek legal advice from your lawyer. Our agenda for today, we are going to cover 3 different topics related to mergers and acquisitions. The first one is we are going to explain the concepts, so a bit of terminology. And then we are going to explain how mergers and acquisitions are formed and structured. And then we are going to explain the process of selling or purchasing a business, different steps and stages that you would need to consider in selling or purchasing a business. Merger and acquisition. These 2 concepts are used together. It's always like M&A, or mergers and acquisitions. And they are usually, sometimes they are used interchangeably. But in fact, in reality, these are 2 separate and different concepts. As you can see on the left side, we have merger, and on the right side of the slide, we have acquisition. And the structure of this deal is, the 2 deals are different. The goal and aim of both of them is to have a larger business and to grow the business. As you can see, the circle is bigger. So the aim of both of them is to grow your business. But the structure and the method to reach that goal is different. So what is merger? A merger is when two businesses, they merge together. They usually the same size, generally they are equal and the same size. They merge, the businesses are combined and they create a new business, a new corporation or a new company, the third one. So company A, business A, is merged with company B or business B. Once they're merged, they create a third company or a third business. I give you an example of my own, one of my own clients. There was a corporation in the field of construction, and my client in the field of UPVC windows. They merged, they created a third company called, let's say, X. That company had more power. In fact, they scaled up their business, both of them. They created a third company and they benefited from the services of each other because one was in the field of construction, the other one in the field of windows, and they created a third company and they could provide services and they products for their projects, which was building condos and services for the windows of those buildings and condos. So this is a form of merger. Two businesses, they merge, they create a third business. And that's a tool, a way of scaling up a business. And it's used to grow the business. In acquisition, usually a business, normally a bigger business, a larger business, acquires another business, and usually a new corporation is not created. The first business gets bigger, as you can see in the picture. So company A acquires company B and it becomes bigger, or again, that's a tool for growing a business. An example of that can be Facebook acquiring Instagram, for example, or acquiring WhatsApp. I know that WhatsApp was a startup when they started, and Facebook acquired WhatsApp and it became bigger. So that's an example of acquisition. And both merger and acquisition are tools to grow a business, to scale up a business. But mergers and acquisitions are concepts or legal terms. How are they structured or how are they implemented? There are two forms, at least in Canada, there are two forms of structuring mergers and acquisitions. It could be either through share deals, selling or purchasing shares, or through asset deals, selling or purchasing assets. These are two different forms of structuring mergers and acquisitions. And the result of these two deals, purchasing or selling shares and purchasing or selling assets, are different, especially with respect to tax and liabilities. Usually, vendors or sellers of a business prefer to sell the shares of their company or corporation, and that's how they sell the ownership of that corporation. And why is that? because by selling the shares, they are transferring all their liabilities in that corporation to the purchaser. So they prefer to sell the shares. Also, there are advantages in terms of tax for the sellers. This is usually like this. Whereas in selling assets or purchasing assets, the purchaser can select which assets they want to purchase. And by assets, we mean like equipment of that corporation, intellectual properties, anything that that business owns, the properties of that business. The purchaser usually prefers to purchase assets of a business because, as I said, they can select which assets they want to purchase and avoid some liabilities of the seller transfer to the purchaser. And there are tax advantages for the purchaser in buying assets. But these are two forms of merging or acquiring a business, either through purchasing the shares of a corporation or assets of a corporation. The process of selling or purchasing a business, that could be either the shares or asset. It doesn't really make any difference. The process of selling or purchasing a business is usually, as you can see in this slide, there are different steps that the sellers or purchasers need to follow to finalize a purchase and sale of a business deal. So far, is there any question? Do you have any questions so far? Any question in the chat?
Nope, not seeing anything in the chat just yet.
All right, okay. The process of selling or purchasing a business, and the reason I'm saying selling or purchasing is that it really, if you're looking from the seller's point of view, that if you're selling a business, but from the purchaser side, you're purchasing, but it's the same deal. The process, it's from a non-disclosure agreement, usually, it's not mandatory, as I will explain it, to finalizing, closing a deal, and some requirements to called the post-closing requirements. So non-disclosure agreement, then letter of intent, due diligence, agreement of purchase and sale, closing, and post-closing. I'm going to explain each step separately, and we start with non-disclosure agreement. When two businesses, they start negotiating about selling or purchasing a business, the seller and the potential seller and the potential purchaser, they want to negotiate a deal. They prefer, or they usually, especially the seller, prefers to have a non-disclosure agreement or a confidentiality agreement. Because during the negotiation phase, many information, especially from that the seller's side, will be disclosed to the other party. And the deal may not get closed, and the seller doesn't really like to disclose to the public, to their employees and the competitors that they were in a negotiation to sell the business and the deal didn't get closed, because that's not good for their reputation. So and also there might be some confidential information, the contracts of that corporation that are going to be disclosed to the potential purchaser, And if the potential purchaser doesn't purchase that business, there must be some barriers not to disclose those information to the public. So it is necessary, at least highly recommended, to have an NDA before starting the negotiation phase in selling or purchasing a business. It is also required for the due diligence purposes. And what's due diligence? I will explain in the next slide. But usually the purchaser of a business needs to know more about the business before making any decision to purchase that business. And in order to get those information and make a decision to purchase or acquire that business, those information must be disclosed to the potential purchaser. And this NDA, or the confidentiality agreement, is required to make sure that the information that are disclosed to the potential buyer are kept confidential. So it is, as I said, highly recommended to have an NDA right at the beginning of the process of selling or purchasing a business. It's usually, as I said, pre-negotiation, and that could be either before the letter of intent phase or in the letter of intent. I will explain in the next slide. But it is definitely before due diligence, before conducting any due diligence. And the purpose is to keep the information of that business confidential. The next stage after non-disclosure agreement, or at the same time of signing a non-disclosure agreement, is the letter of intent. The letter of intent is usually 1 to 2 page document. It's not very formal. It's the summary of the negotiations that the purchaser and buyers usually have about the business, how to start the process, how to purchase that business, how to sell that business, the conditions. All the negotiations that are just informal, not formal, not legal, are usually brought into the form of a letter, as I said, usually 1 to 2 pages document. And it's not mandatory, it's not required to have a letter of intent, but it's good to have a letter of intent that summarizes the negotiations. And it could be used as a roadmap to draft the agreement of purchase and sale of a business. So it could be used as a roadmap, as a guide to draft the contract. And it is usually non-binding. It's not a contract, as you may remember from our first session. A letter of intent can be or is an agreement, but because it's not binding, it's not a contract. It's just an agreement. The parties sign. It's a document that both parties sign, but it doesn't have, it's not legally binding. It's not a contract. It's just an agreement. And the confidentiality clause or non-disclosure agreement that we discussed sometimes is a clause in the letter of intent. If the non-disclosure clause or confidentiality clause is within or inside a letter of intent, that part is binding, because an NDA or a confidentiality agreement is binding. The rest, the negotiations that are usually in the form of some bullet points, those are generally not binding. But this clause are most of the time the non-disclosure agreement clause. If it's in the letter of intent, that clause is generally binding. So we discussed that the two parties, the seller and purchasers, they usually start with a non-disclosure agreement, and then they start their negotiations, and they transfer the negotiations into a document called the letter of intent. Once the letter of intent is signed, we move to the third stage, which is called the due diligence phase. The purpose of due diligence is to make sure that the business is sound. And it is usually conducted and done by the buyer's lawyer or the buyer, to make sure that the business that they are buying and purchasing, it's a sound business. It doesn't have any problem or any issue. They do a background check. Due diligence is in fact a background check of that business. Financially, legally, there is no issue with that business, so that the purchaser can make sure and purchase the business without facing any financial or legal problem. As I said, the due diligence is usually conducted by the buyer's side. And it's usually also done by the accountants or financial advisors of the buyer and the lawyer of the buyer, because we have financial and legal due diligence. These are some of the documents that the buyer or the buyer's representative, either financial advisors or lawyers, they go through all these documents to learn more about the business. And generally, it starts with financial. This is not a standard type of doing due diligence, but most of the time, the accountants or financial advisors, they start investigating and going through financial statements of the business to see if there are any problem with the financials of the business, and also the tax returns of the business. Once there is a green light by the financial advisors and the accountants, or once the financial aspect of the business is clean, then the legal due diligence starts. But as I said, this is not a fixed formula, and sometimes both legal and financial due diligence are conducted at the same time. In terms of legal due diligence, the lawyer or the buyer, without having any lawyer, but they start conducting investigation on corporate's records or the corporate's minute book, the main documents of that corporate. They go through the articles of incorporation, the certificate of incorporation, bylaws, all the documents, and if there is any amendment to any of the documents of the corporation, and they make sure that that's a corporation that is registered without any problem or issue. Also, the lawyers, they go through the material contracts, the most important contracts of that business. the shareholder agreements, for example. They make sure that the shareholder agreements doesn't have any problem, or they don't limit the shareholders to sell the business, or if there is any clause with respect to selling the business, they make sure that as a condition, the shareholders and directors of that corporation approve the sale of that business. They go through the employment agreements, lease agreements, any material contract or agreements that that corporation has, to make sure that there is no barrier to sell that business. And if there is any, that could be a condition before closing or selling the business, to get the approval and make sure that this sale or that deal on the business is authorized. They also, as part of the legal due diligence, the licenses and permits of the business must be examined to make sure that all the licenses are obtained and are up to date. Also, some public searches must be done to make sure that the properties of the business are not under lien, or there is no security interest on the properties of the corporation or the business. There is no litigation or claim against that business, to make sure that that business is not insolvent or bankrupt. So the legal due diligence is a tool to make sure that the business is registered, is running, and there is no impediment or barrier for that deal, for the sale of that business. Once the due diligence phase is completed, the lawyer usually and the accountants, financial advisors, they give a report to the buyer. Based on that report, the buyer, the potential buyer, can proceed to the next stage, which is the agreement of purchase or sale of a business. If the result of due diligence is negative, like there are many problems with that business, usually there is no other phase or step. The negotiations end here at this stage, and no further action will be done by the potential purchaser. But if the problems are minor, or the issues are minor, or there are no issues with the business, then the parties move to the next stage, which is the agreement of purchase and sale of a business. Any question, any point?
Nope, nothing in the chat yet. Does anyone have any questions? They're more than welcome to, again, unmute themselves and ask their question, or if they don't feel comfortable doing so, put it in the chat and I can relay it.
Perfect. Agreement of purchase or sale. Sometimes it's called agreement of purchase and sale. If the agreement is drafted by the purchaser's side, the purchaser's lawyer, it's called agreement of purchase or share purchase agreement, asset purchase agreement. There are different terms for that agreement, but they're all the same. It's selling a business and purchasing a business for the other party. These are the main elements of an agreement of purchase and sale of a business. I'm going to later show you a sample of an agreement of purchase and sale of a business. But it usually starts, as you can remember from our first session, it starts with recitals, the title, then recitals, the background of how the parties have decided to make this agreement, and then definitions. After definitions, the mutual covenants or rights and obligations of the two parties, seller and purchaser. Of course, one of the covenants is for the seller is to sell the business, transfer the ownership and title of the business to the purchaser, and for the purchaser to get the title and transfer the purchase price or money to the seller. This is one of the main covenants of the agreement of purchase and sale. The other part or clause in an agreement of purchase and sale is to set a purchase price and a method for the payment of that purchase price. Whether it's selling the shares or assets of a business, there should be a purchase price defined for that business. And sometimes the payment is all cash at the beginning, once the deal is closed. Sometimes it's cash and some other forms of payments, installments, or giving loan, financing the purchaser. There are different forms of payment, paying the purchase price, and that must be defined in the purchase price clause. The other part of the agreement of purchase and sale covers the process of closing this deal. I should highlight here that the agreement of purchase and sale is not the final step. It's just a guide for the purchaser and the seller to finalize the deal later. Once the conditions are met, then the deal is closed. So the agreement is just a guide to close the deal in the future. Once the conditions, which I'm going to explain later, but once the conditions are met, then the deal is closed and the ownership is transferred to the purchaser, and the purchase price transferred to the seller. This agreement defines the conditions, the obligations, the rights of the parties to close the deal in the future. Usually it takes about, it really varies. Sometimes it's 1 week after this agreement, sometimes 30 days, 60 days, depending on the conditions. After this agreement, the deal gets closed later, once the conditions are met. So that process must be defined in this agreement. There is a part in this agreement called the representations and warranties clause. Representations and warranties, if you may remember from our first session with respect to agreements, are the facts that one of the parties represents, affirms that these facts exist. Let's say, for example, the seller represents that the business is registered in the jurisdiction of Ontario and it's a sound business. There is no claim against this business. This is a representation. And misrepresentation, if they misrepresent a fact, could lead to a cancellation of the deal. So it's important to make sure that whatever one of each party represents is true and accurate, because then if later on it's it's found by the other party that the representation wasn't accurate and true at the time of signing the agreement, that is considered as a misrepresentation and can lead, as I said, to the cancellation of the deal entirely. And in agreement of purchase and sale, in mergers and acquisitions, representations and warranties are very important because the two parties, they rely on each other. Based on those representation, they move to the next phase, which is closing the deal. Closing conditions are some events that must happen in the future or before closing the deal or after closing the deal. So it's some events that must happen to close the deal. For example, one of the conditions to close an agreement of purchase of a business is to make sure that the seller obtains the approval and authorization from all the shareholders or directors of the corporation. Without that authorization, they might not be able to transfer the shares to the new purchasers. That's a condition. Or let's say the property of the business is under lease, and one of the conditions is to get authorization from the landlord. That's a condition. The parties sign this agreement and make it conditional to get those approvals and authorizations from third parties. Indemnification provisions are usually provided by the seller, but again, both parties can provide these indemnification provisions. Let's say the seller indemnifies the purchaser from any liability, any claims prior to closing. The liability is on the seller for any claims that are the source of any claims that are before the closing. This is an indemnification clause in favor of the purchaser that binds the seller, and all the liabilities will be on the seller for that period before closing. And then we have standard legal provisions, or the boilerplate clauses, as we discussed in our first session. Those are usually the clauses towards the end of the agreement about the applicable law, method of resolving disputes, different termination clause, communication and notices, the standard legal provisions towards the end of the agreement. This is the general format of an agreement of purchase and sale, and as you can see, it's not very much different from the template that we discussed in our first session for the agreement or legally binding agreement contracts. The most important part for agreement of purchase and sale of a business are the process of closings and closing conditions. The rest are usually the same as other types of agreements. And as I said, I will later show you a template, and you will see all these elements in an actual agreement of purchase and sale of a business. Once the agreement of purchase and sale is signed, then there will be a period around, as I said, it really varies, but around 1 week to sometimes 2 months to the second to the next stage, which is closing of a deal, closing of a purchase or sale of a business. And that's when the deal is finalized. As we said, the agreement is binding, but it doesn't transfer the ownership of a business to the other party and the money to the seller. It doesn't do that. It defines the terms and conditions for the transfer of title and money in the future, once, one, the conditions are met, and two, closing documents are exchanged. That's when the deal is final and the seller has sold and transferred the business to the purchaser, and the purchaser has paid the purchase price. The deal is closed and final. So one more time, the closing is the stage when the money is transferred to the seller of a business and the title or ownership of the business is transferred to the purchaser. And there are two stages. When the conditions are met, as I said, the conditions that are stipulated and expressed and mentioned in the main agreement. Let's say the approvals are obtained, the authorizations are obtained from the directors, the landlord, all the conditions are met, and the closing documents are exchanged. Then the deal is final and closed. But the process of selling and purchasing a business is not finished here. There are some other requirements post-closing of a deal. At this stage, the title is transferred, the money is transferred, but there must be some other requirements must be met. Some corporate filings must be done. Some notice of changes must be submitted to some governmental bodies and agencies. For example, if the directors and officers will be changed, that must be sent. The notice of changes must be sent to the government of Canada if it's federal, or Service Ontario if it's a provincial corporation. If there's a business name registered, then that business name must be changed from the previous owner, the seller, to the purchaser, and some amendments on the documents of the corporation must be done. These are post-closing conditions. We had condition precedents before the closing. Some approvals and authorizations had to be taken from third parties, for example. Those are conditions precedents. And these are post-closing conditions. The corporate filings are among the most important post-closing conditions. Without these changes, some institutions, let's say the bank accounts information must be changed to the new owners, the purchasers. Without these, the public, that could be the governmental bodies such as the Government of Canada for corporations, financial institutions, those third parties, they still don't recognize the purchaser, the new owners, as the owners of the corporations. That's why these post-closing notifications must be submitted right after finalizing the deal. And it's very important. So once the contract is signed, the deal is not final, we have the closing stage. Once the closing is done, still, the deal is final, but there are post-closing requirements. These stages must be followed one after the other in order to have a complete deal on selling and purchasing a business. If anybody, do you have any questions so far?
Still nothing in the chat.
Nothing in the chat. Okay. I'm going to show you the template just to give you, just to show you a sample of an agreement of purchase and sale. You can see it was just, I drafted this on May 1st, just 10 days ago. This is a share purchase agreement. It's quite simple because the two businesses were very small, and it was the transfer of 50% of the shares of one of the corporations. It starts with the recitals, then definitions, the purchase price, the purchased shares, and the price, and then closing arrangements or the closing procedure. What should happen on the closing date? A copy of a resolution of the directors of the corporation authorizing the transfer of shares, the registration of the shares in the name of the transferee, and the issuance of new share certificate representing the shares registered in the name of the transferee must be obtained. Resignation of the transferor as the director and officer of the corporation must be drafted and signed by the transferor. Consent of the other shareholder and the landlord. These are conditions, the authorizations and approvals that I mentioned earlier. These are called the conditions. These must be obtained in order to finalize the deal. And then the conditions, representations and warranties. The transferor represents and warrants that as of the closing date, the transferor has title to the shares in the corporation. The transferor is not a non-resident within the meaning of the Income Tax Act, and etc. Some representations and warranties from the transferee, and then indemnification. The transferor will indemnify and save the transferee harmless from all liabilities, claims, actions, losses, damages, and expenses, including legal fees and disbursements for the period before, from any event occurred up to the closing date. This is a sample of an indemnification clause. And then the boilerplate clauses or the standard clauses, entire agreement, cost amendments, governing law dispute resolutions, and notices. These are just standard clauses and signature. So this is a very simple and a short version of a purchase agreement of sale or purchase of a business. And by the way, this was selling shares, not assets of a business. I think I'm done with my slides. Yes, it's finished. Any question, any points? Are you, any of you, like, are you in the stage of selling your business or purchasing a business? Are you dealing or are you considering to purchase a business, any of you? Or selling your business, joining and merging with another business. No. Tracy, Chloe, Heidi.
Nope, still no questions. Like I said, if anybody wants to unmute and ask their question, they're more than welcome to do so. Otherwise, you have Shokouh's email there and her phone number. But otherwise, thank you so much for today's wonderful presentation. I will put the email in the chat again in case you missed it. But if you would like a copy of today's recording or the first recording from last month, please let us know. We're more than happy to send it to you. Thank you so much again, and have a great day, everybody.
Thank you, Kylie. Have a great day.